Mame fa na sema PENDREAM TV. PENDREAM TV de osia dem yopo.
Abusuafo ne atifo yemo bibia akwaba PENDREAM TV so ni. Se na no first time subscribe to channel no. Ja wadwenkyere e wo comment section ho. She adwumadi no na ma afoforo ensa enka bi. Yensa ka news bi e de ba bonten. Me pese mesel mre no wada agi ntino. Kame ho na yenti ensema e wo news no.
Some chanting and singing by excited NDC supporters here at the High Court. The excitement quite evident here at the High Court. Well, after 6 hours of sitting today, the court has set January 4, 2025, which is a Saturday, to give its ruling on the Mandamus application filed by the New Patriotic Party, the NPP, to have the EC collate results or conclude collation of results in these 4 disputed constituencies, 3 of them in the Greater Accra region, 1 in the Bono region. Earlier, the court also dismissed the preliminary objection by the NDC to the court's powers or jurisdiction to hear this Mandamus application filed by the NPP. My colleague Hansen Adjournment was in court for us. He is joining us to run us through or give us a summary of the 6-hour hearing and basically who the various actors are, the interested parties are, and what exactly transpired in court today. Hansen, thank you so much. We know that the NPP had filed a Mandamus application in the court. There was a subsequent objection raised by the NDC. Today, we have heard that the court dismissed the preliminary objection by the NDC and has set January 4 for its ruling. But really run us through the details of all these various stages of the court process.
So the preliminary objection to a large extent operated as, if for want of better words, an obstacle to the hearing of the matter itself. And so until the preliminary objection would be dealt with, the substantive matter cannot be touched. And so the ruling on the preliminary objection was very important. And so the court's decision to dismiss it then now paved way for the NPP, who are plaintiffs in the matter, to properly move the application for Mandamus. And because 4 constituencies were involved and they were not joined together, so the lawyers had to move them individually. But for the lawyer of the NPP, he decided to give a broad legal reasons as to why the Mandamus application should be given by the court, and then later went on to apply the general laws specifically to the individual constituencies. And his arguments primarily are that the Electoral Commission as a body mandated to conduct election, for which this conduct of election includes collation and declaration of results, have not done so. And evidently between December 8th, after election was done, polling station results have been gathered across these constituencies, to January 1 today is a long time for which the Electoral Commission ought to have collated the results and declared same. And he also added that they had sent a petition to the Electoral Commission for the Electoral Commission to conduct, to collate the results, for which the Electoral Commission refused to do so. So on that level, they believe that they had met certain conditions to come to court to ask for the High Court to direct the Electoral Commission to go back and do its work. He makes the point that if anybody is to say that elections have been declared and the results are known, then you need to be guided by the provisions of CI 127. Regulation 43, he says, makes mention of a parliamentary collation sheet and a collation summary sheet. This sheet, we are told, has on it the valid vote each candidate has attained who attained the highest vote and who is the winner. The absence of this sheet and also the election summary sheet, the collation summary sheet, then the NDC cannot claim that there was any declaration properly so called. He then touched on videos of presented in court by the NDC showing that there were declarations and indicated that those declarations, particularly in the case of Tema Central, was done by a person who was not the returning officer, and so such a declaration cannot lie. And in some of these constituencies, he makes the point that the declaration was done without considering some other polling station results. For instance, in the case of Tema Central, he talks about 2 outstanding polling stations. In the case of Akaikwe Central, he talks about 30 polling stations, which were not included in what the NDC claimed to be a declaration. And to add to this, he says the Electoral Commission itself has agreed and has told the court in its affidavit that indeed, as a commission, it has not done its work properly so called. And so the commission itself is agreeing with the NPP that the court should order for them to go and do the collation with a limited number of people as contained in the electoral laws. And it is the view of the lawyer of the Electoral Commission that you cannot have as many people as the many party supporters that we saw gathering around the collation center or in the collation center, because according to him, the law stipulates the number of people who can be at a collation center. So the NPP lawyer argues that if you look at the admission on the part of the Electoral Commission, it is only right that the court agrees with it and grants the Mandamus application. But the NDC disagrees. The NDC says for Mandamus to lie at common law, there are certain conditions that ought to be met. First, there has to be a demand to the body you are requiring them to make that to perform that duty, and that demand should be clear and unequivocal. They say that at common law as well, the body should have refused not to perform that function before you can come back. You can actually go to court for a Mandamus application. And they argue that the letters exhibited by the NPP does not show anywhere that they made a specific demand to the Electoral Commission to actually collate the results, and they don't see any rejection also on the part of the Electoral Commission. And so that condition precedent, in the words of the lawyer for the NDC, Godwin Rejệcts, then the court cannot entertain the Mandamus application. He also goes to say that declaration has been done, and he put out videos of the 4 candidates in these constituencies being declared. He says they believe that the declaration has happened, and once the declaration has happened, the election has been concluded. The powers of the court to enter into it can only be through an election petition. He believes that the NPP's case is to question the veracity of the declarations, which he believes goes into the substance of an election petition. And so he, one way or the other, re-argues the preliminary objection that he had brought to court earlier. And based on all these, he's urging on the court to dismiss the applications and he's urging on the court to dismiss the applications, and also then by so doing, then what it means is that the NPP or the Electoral Commission cannot go back and do the collation. He's saying that if the NPP really has any issues whatsoever with the declarations that have been done and the results, then they now have to come back to court by way of a petition. And so after 6 hours, the court decided that it would take 2 days to review the arguments, to read the relevant laws that have been cited, and then hopefully on Saturday, January 4, 2025, the judge has given an indication that he will give a ruling on the matter.
Very well, Hansen. Thank you so much. Hansen Adjournment there, our court correspondent. He sat through that 6-hour hearing, which concluded with the judge adjourning and, of course, setting January for 2025 for the ruling on the Mandamus application by the New Patriotic Party regarding parliamentary election results in 4 disputed constituencies. Earlier, as Hansen explained, the court rejected or dismissed an objection raised by the NDC to the court's powers or challenging the jurisdiction of the court to hear a mandamus application as filed by the New Patriotic Party. My name is Nana Tufo Boateng. Many thanks to you for staying with us. Obviously, we'll be bringing you more updates in our subsequent bulletins and programming.
Nana Tufo Boateng there with my colleague Hansen Adjournment reporting live from the court complex in Accra. The story from there is that the High Court in Accra has adjourned to January 4, Saturday, 12 noon to make a judgment on the NPP's Mandamus application filed to compel the Electoral Commission to recollate election results in some 4 constituencies. Okankwe Central, Ablekuma North, Tema Central, and Techiman South. Now, this follows the court's earlier rejection of the NDC's objection that they raised on the court's jurisdiction to hear the Mandamus application.
Subscribe to the channel, like and comment, share Jurisdictional nama afofro eza enkami.